If you are planning on starting a small business with other individuals, or if you're already a part of an ownership group, a shareholder agreement is an essential part of your ownership. Hi, I'm attorney Matthew Sheahin, a partner at Lavelle Law. Over the past 18 years, I've represented numerous parties in shareholder disputes covering many topics and issues. In general, a shareholder agreement will cover critical aspects of running a business with multiple shareholders, including issues like how the business is to be run, voting rights, how and when profits are paid, succession plans, who the officers and directors are, and what method will be used to evaluate the business. Unfortunately, even with a well-crafted agreement, shareholder disputes can arise when one individual or a group of individuals feels that they are being excluded, oppressed, or feel that the other owners are acting illegally. If your business is an S or C Corp, the Illinois Business Corporation Act will provide courts with direction on how disputes may be handled. Similarly, the courts follow the Limited Liability Act for disputes involving LLCs, or the Partnership Act for partnerships. While it is always beneficial to avoid lawsuits, in some cases the owners will be deadlocked on how to resolve a dispute and a legal process will ensue. Section 12.56 of the Business Corporation Act lays out specific remedies available to the court in cases in which a deadlock is preventing the business from functioning. These remedies include the setting aside of actions of the corporation or canceling sections of the bylaws. The court can remove officers or directors. It can appoint a third party as an officer or custodian, order payment of dividends, award damages, can direct the parties to mediation, and in some cases, require the majority shareholders to purchase minority shares at a fair market price. And lastly, even the dissolution of the company. A minority shareholder is a person or group that owns less than 50% of a business. When a minority shareholder feels that they are not being included in decisions according to the shareholder agreement or not being informed of corporate actions, the Business Corporation Act and similar acts for other entities provides them with the right to see books and financial records for proper purposes. These records may include tax returns, bank statements, and copies of checks, including payroll records. These types of shareholder disputes are often quite complicated and can be time-consuming to pursue, but in some cases are unavoidable. It's important to note that the court can determine what it considers the best remedy to be, regardless of what remedy the plaintiff is seeking. So experienced representation is critical. If you are a shareholder in an S or a C Corp and feel that your rights are not being upheld, give me a call at 847-705-7555 and I'll be happy to meet with you for a free consultation. Of equal importance, if you're thinking of starting or buying into a small business with others, or even if you are a shareholder in a successful business today, you can avoid many common disputes by drafting a sound shareholder agreement now. Give me a call and we'll get started.
To learn more about remedies available under the Illinois Business Corporation Act and to review options for resolving shareholder disputes, give Matt Sheahin a call at 847-705-7555 or visit lavellelaw.com. With more than 18 years' experience in representing minority shareholders, Matt Sheahin will work to reach a fair resolution on your behalf. To set up a meeting regarding a dispute or to create your new shareholder agreement, call 847-705-7555. That's 847-705-7555.